Hi, everyone. I'm Ashwin Phatak, Appellate Counsel at the Constitutional Accountability Center in Washington, D.C. Today, the Supreme Court released two important decisions in cases involving the president's financial records. They offered a bit of a mixed bag, so let me break it down. The first case was Trump v. Vance, and that case involved a subpoena from a New York State grand jury for the president's tax returns and other financial records. The Supreme Court held essentially that the president is not absolutely immune from these types of subpoenas, and that, in effect, he does have to comply with this subpoena and turn over his tax returns and other financial records to the grand jury. And that's really a big victory for the rule of law and for the notion that the president is not a king in this country. In that case, the president had offered a theory that he was absolutely immune from any type of subpoena in a case, in a criminal case where an investigation is requiring the president's documents, even if those documents are personal documents, not documents that are that might be covered by executive privilege or are in some other way related to the president's official duties. So in this case, the New York State grand jury was conducting, and it continues to conduct, a criminal investigation into possible campaign finance violations, and was requesting the president's tax returns and other financial documents as part of that investigation. And the Supreme Court rejected the theory that the president is absolutely immune from these types of investigations. The court relied in large part on two prior decisions, one involving President Nixon and one involving President Clinton. In both cases, the court had permitted these types of judicial processes against the president to go forward. And so the court in this case said that similarly here, any burdens or stigma on the president for being a part of a criminal grand jury investigation were not enough to impede the president from being able to carry out his executive functions, and therefore that the subpoena could go forward. The court also rejected an argument by the Department of Justice through the Solicitor General's office that basically argued that these types of subpoenas should be subject to some kind of heightened standard because the president is involved. The court said that there doesn't need to be a heightened standard, and that's even true for a state criminal investigation, which this is one. So really, overall, I think that this decision was a major win. These tax returns will now go to a New York State grand jury as part of this investigation. It means that this president and future presidents need to comply with criminal investigations. And, most importantly, it means that an investigation that relates to a president can go forward, and that just because a person is the president of the United States doesn't mean that they can't be subject to criminal liability down the road, and that they can't be required to participate in this kind of, important criminal investigation. The tax returns will remain secret for the time being because New York State grand jury laws require secrecy for grand jury materials, but that still means that the investigation can go forward, which is an important decision. The second decision is the Supreme Court's decision in the Mazars and Deutsche Bank cases. Now, these cases concern congressional subpoenas for the president's financial records, although they didn't concern specifically the president's tax returns. This opinion was a little bit more of a mixed bag because, on the one hand, the Supreme Court did say that Congress has broad investigatory powers and that Congress can investigate the executive branch, especially in the case where an investigation relates to a legitimate legislative function. And that's a really good thing that reaffirmed decades of Supreme Court precedent in this area, and it comported with really centuries of history in which the president and the executive branch has been subject to congressional investigations and congressional subpoenas. In addition, the court, again, in this case, much like in Vance, rejected the really stringent heightened standard that the president and the Solicitor General had put forward to try to limit Congress's powers to investigate the president, basically saying that that standard doesn't apply in this circumstance and really only applies to official communications of the president that might be subject to executive privilege. It doesn't apply to personal financial records of the president like the ones at issue here. The reason the case is a little bit of a mixed bag, however, is that the court then went on to say that there was some level of a heightened standard when records are requested from the president in particular, or that pertain to the president. And basically, the court said that courts that deal with these types of subpoenas need to carefully consider whether or not Congress can get the information they're requesting from another non-presidential source, whether the reasons that they're requesting the documents are sufficiently good, and whether there are any special burdens on the president that would result from these types of subpoenas. That all is okay as far as it goes. The issue is that this case now goes down to the lower court, which will have to decide anew whether or not the subpoenas in these cases comport with this new standard that the Supreme Court has put forward. The court should do that as quickly as possible, but it's not at all clear that it will. And it really is going to be up to the DC Circuit and the Second Circuit, the two lower appellate courts here, to deal with these issues as fast as they possibly can, even in a matter of days or weeks, if they can do so, which they really should be able to do, to deal with this new standard, apply these subpoenas, the standard to these subpoenas, and decide whether or not these subpoenas can go forward. And they need to do that quickly because this congressional term is going to wrap up very soon at the end of this year, and there's going to be an election this fall. And so it really is incumbent on these lower courts to move quickly and decide whether or not these subpoenas can go forward so that the president can't use this litigation to delay enforcement of these subpoenas any further. So that's what happened today. If you want more information about these cases, you can go to our website at www.theusconstitution.org or click on the link below. And you can also go to our website to learn about any of the other cases that we're working on dealing with the US Constitution and the rule of law. Thanks so much for tuning in.